In the case of 096979, Andrew Bailey, debtor's motion to extend exclusivity period.
Good morning, Your Honor. Andrew C. Bailey, self-represented.
All right, Mr. Bailey, this is your motion to extend the exclusivity period?
Yes.
How much time are you seeking?
Well, as I laid it out in my motion, seeking an additional 120 days.
Well, let me ask you something. I mean, I think isn't this case basically about the 3 parcels up in the Cottonwood area and the parcel in Glendale, California?
Exactly, and the conflicts there. And I'm aware of your, just yesterday discovered that you had made a ruling about which I'd like to make some comments.
Let me ask you a blunt question. It occurs to me from everything I've read here that I think in general you don't dispute that the money's owed to somebody, right?
I do not dispute that the money's owed to somebody. I do dispute that the foreclosing parties are the creditors. I definitely dispute that. I believe I provided incontrovertible evidence to that effect.
Well, I'll leave it this way. I'm not sure I agree with you on that point.
Fair enough.
I have some sense that whether the money's owed to Wells Fargo or to someone else, in terms of getting a plan on file, I mean, I think this case is about 8 months old.
It is 8 months, yes.
It's probably sooner rather than later.
I absolutely agree, Your Honor. I've been asking for what I think is a pretty simple series of answers. Firstly, I've been asking for discovery and for the court to allow discovery so that we can get to those answers. But the questions are really simple. Who's the creditor? How much do I owe them? And we can't get there without disclosure of who the creditor is. And in the pre-securitization world, that was a simple question. It is no longer simple. These properties have been transferred.
Well, I mean, for example, you've got the declaration from Wells Fargo on one of the Cottonwood parcels that says, we originated this loan, we've never sold it or transferred it, we still hold it, and they're the party who's filed the motion for relief from stay. So
right.
There's no indication that that loan has been securitized, pooled, whatever.
I absolutely agree. In that particular case, Your Honor, there's no question about that. Asking for a full accounting because the other issue at the other end of it is what is the outstanding, what is still owed on that obligation. It may be the full amount, it may have been paid off. I do have experts who say that the chances are it has been paid off, as we discussed at the last hearing.
Well, I want to make sure I say this in a correct fashion. And I forget the gentleman's name, but the declarant makes a lot of general statements about the lending industry.
You mean my expert witness?
Right. And what might have happened. But he makes no specific statements about these loans, that anything actually happened with them. And a lot of his references, to be blunt, I think are misstatements in this sense. The fact that TARP, the Troubled Asset Relief Program, and these other federal programs provided money to banks and other lenders to keep them from failing, did not pay off the debts that held by those entities. And so when he starts making that statement, to my knowledge, he's just flat wrong.
My understanding there, Your Honor, is that certain of that money would be applied to those troubled assets. If I had a loan that was in default and the taxpayer bailed out the bank because my loan was in default, my loan would have been satisfied. Perhaps not.
I have to tell you, Mr. Bailey, and I'll be the first to acknowledge that it's not an easy field to make your way through, but exactly. I can say with a high degree of certainty, to my knowledge, as I sit here today, the money that was advanced by the federal government on all these programs was not used to pay off individual loans. And the best evidence of that is there have been multiple what I'll call loan modification programs, either directly sponsored by the federal government or indirectly encouraged by the federal government. And that's a pretty strong indication that the individual loans that were in default were not paid off by the TARP money and these other federal bailout programs. And I will share with you in preparation to speak at a program about 4 or 5 months ago, I spent a fair amount of time going through the entire, what I'll call federal bailout program, how much money was spent out in TARP, how much money was spent out in these other programs. And in none of that work did I see anything that said these advances paid off individual loans held by these various lenders, including the Wells Fargo group that holds, I think, 3 of your 4 loans.
That's right, yeah.
The other thing, generally, credit insurance and credit default insurance, when that's activated, what happens legally is if there's some insurance payment that pays all or some portion of that debt, the insurance company is subrogated or otherwise succeeds to the rights of that lender, so that if they, for example, entirely paid off some mortgage loan because they were obligated to do that under their insurance program, then they became the owner of that loan and had the right to collect that debt. The debt was not discharged.
Understood. Yeah.
So all this is a long way of coming back to, I really think it's time for you, I'm going to give you some more time, but I think it's time sooner rather than later to file whatever plan you want to file to try and reorganize your debts under Chapter 11. I'm inclined to say 60 days. If you want to try and talk me into more time, I'll listen to you. But in my mind, I think the money is owed to some lender, whether it's Wells Fargo, Bank of New York, or some other entity holds one or more of the debts that you owe. And it's probably time for you to tell them and the court how that's going to be dealt with.
I think it's impossible to know 60 days or 120 days. I just don't have a frame of reference for that, Your Honor. So I think 60 days is fine. If you gave me more, I would accept it, obviously, because the challenge here is I need to appeal these decisions.
Well, you're free to do whatever. You want.
And let me just say this, if I may, with regard to the 2620, the one where Wells Fargo put in.
Well, let me say something.
Yes, sir.
You understand these parcels by number a lot better than I do. Right. I had to spend some time because you all talk about them by, I guess, their address number.
That's right.
Which is a little bit difficult for me to track. So I know there's 3 in Cottonwood. I know there's 1 in Glendale. If the 2620 is the one that Wells Fargo filed the declaration
with the young lady at the last hearing.
It said, we've always held this loan. We've never assigned it.
And in that particular case, I absolutely agree. There's been no evidence of securitization. And therefore, I really may not have a case. I felt that from the start, but I was advised to investigate it and see if we could get them to provide this information. A full accounting and a disclosure of who if there had been any reconveyances. In the other 2 cases, which are the 2500 North Page Springs Road in Cornville and the 153 Western Avenue in Glendale, there is no question that they were securitized. There is no question that they were reconveyed, that the loan was reconveyed, in one case to U.S. Bank, in one case to Lehman Brothers. There's no evidence whatsoever that they were ever reconveyed back to Wells Fargo, or that Wells Fargo has any authority whatsoever to enforce the note. That's my problem with it, and that's the basis I have to appeal it on.
Well, like I said, you have the absolute right to appeal any decision made in this court. That's the law.
And timing-wise on that, I have to put in a notice of appeal within 10 days. Is that correct?
Well, you need to understand my role. I'm not supposed to give advice to anybody, and I try to stay on the right side of that line as best I can. So I think you're now asking me for legal advice.
Okay.
Again, I referred you to the Self-Help Center.
That's my understanding.
County Bar Law Referral Program. I'm going to say this rather bluntly, so if it's considered rude, I'll apologize. I would urge you to go get some legal advice from whatever resource you can, for a number of reasons I've said previously. I will tell you this. I'm going to order you to file I'm going to grant your motion to give you 60 days from today to file your plan.
Thank you.
If you don't, that doesn't mean you're automatically out of Chapter 11. That just means you're not in compliance with that order.
Right. And
it means that if one of your creditors wanted to, when exclusivity terminates, they could file a plan. I have to tell you, looking at the docket, I think it's extremely unlikely that any of your creditors are going to file a plan a creditor's plan in your case. I think you're either going to make it in Chapter 11 on your own or you're not. And if you don't, then you're either going to have to dismiss or convert your case. And if you do, then you'll get a plan confirmed and have a new arrangements with the affected creditors.
That sounds right to me too, sir.
All right, so you'll have to and including, make sure it's not a holiday, Monday, May 3rd, to file your plan and disclosure statement, May 3rd of this year. And I'll extend the exclusivity period to that date and give you an additional 60 days thereafter to solicit and get your plan confirmed.
Right.
All right?
Yes.
All right. And let me tell you again, sir, go get yourself a good lawyer and get yourself a little legal advice, even if you're not going to retain him in this case.
Your Honor, I have tried really hard.
I know it's difficult for a lot of reasons,